What is the difference between a patent, a copyright, and a trademark? Let's start there.
Okay, so patent, copyrights, and trademarks are all intellectual property. And what intellectual property is, it's like something that you create with your mind, right? It's like a creative expression. And those different areas are areas that you could create, you could protect your creative expression, right? So a patent is a protection that you get for an invention. So if you have something that's new, that's innovative, that's going to change the way that people, live and work, technology, those things are patentable and they're very technical, right? So you actually need to be a patent attorney to practice patent law. But those things patents are going to protect inventions. Okay. Copyrights are going to protect literary works. So certain things that you create, but it has to be expressed. So it can't be an idea. So intellectual property can't be an idea. You can't protect an idea. Okay. So you have to express it. So if it's a writing, a story, you got to write it down. If it's a song, you have to write the lyrics, or you could record the music. If it's art, you got to draw, it has to be drawn or whatever. It has to be expressed so somebody could perceive it.
That's for trademarks.
That's for copyright.
That's
for copyright.
And then trademarks?
And trademark is basically gonna bring somebody back to the source of a good or service, right? So it represents your business, your brand, and it's gonna put the public on notice to know where to go for that particular product or item. So there's two reasons. One, you want to protect your work, right? So you create something, you have a business, you put all this sweat equity into it, and you have goodwill. As your brand grows, they expect a certain quality, a certain standard from your brand. So you want that to be protected so you can make money off of it. And then the government, the Copyright and Trademark Office, they want to make sure that if somebody gets hurt from your product or your service, that they know who to go to for that. Right? They come for you.
So the Fortnite, when they were trying to do the dance moves, that's a copyright issue, right?
Yes.
It's a copyright issue. Because I just want everybody to understand, because legal jargon can be a little confusing, right? And even for I'm in business and I'm kind of confused by copyrights and trademarks. So, all right. So, the dance moves is a copyright because that's something that it's physical thing that they made up.
Right. So they created it, and it's it's something physical that they did. It's a creative expression, choreography, dance moves. And there's going to be an issue even with that when they go to copyright those, because from what I understand, Alfonso Rivera, the Carlton dance. So he already got denied because they said it's only 3 moves. It's not enough to be choreography. And I think that's gonna sort of change the way the law is, because now everything is media. Everyone has a camera. Everyone's creating dances, doing all this type of stuff. That has to be protected somehow.
Yeah. So when Black Boy JB, he does that move and the kids just recreate it. Right. That's not really choreography is what they're saying.
Yeah. So that's going to be an issue. I think that's an issue that's up for discussion.
Yeah. And then, all right. So then the trademark, the Jordan logo, that's a trademark, right?
So in that case, they sued for copyright because the person who took it was a photographer. So photography, it's a picture. That's going to be something that's going to be copyrightable. Mm-hmm. So they're suing for the photo that what was it, that Nike did, the comparable photo, but also comes into question because now they use that as a logo, right? But he lost because they said it's really not substantially,
And it's interesting too because
I think they not to cut you off. They said that the tracksuit was the
it was the backdrop in the picture, the tracksuit, and the photos are slightly different. And it's interesting too because people were saying, well, you can't take credit for an image, but you actually can, because I remember when Cameron had the album. I don't know if you're a Cameron fan, but we're Cameron fans.
Okay. So then I'm a Cameron fan.
Yeah, of course.
He had an album called SDE a while ago, and the logo was the NBA logo, which is Jerry West. Mm-hmm. But instead of the basketball, it actually had a firearm in his hand. So long story short, the NBA wasn't too happy about that. Right. So they shut it down, and he couldn't use it. Yeah. So it's just interesting to see that, somebody can come up with an idea, but if they don't actually do the right legal steps to somebody else can kind of take the idea and now they own it.
Right. And that's what's been happening for years. Like people who are ignorant to this type of protection that it exists. Yeah. They just create stuff, and people who know, they take it. And, just like all of the artists that came, like, in the 80s, 90s, 60s, like they didn't know that they had an actual, asset that someone else is making money off.
Yeah, and that's what we want to really, because especially in our community, like we're very creative, we're creative people, but we don't always understand the business side of things and how to monetize it and the legal steps to take. So like you said, I mean, we'll make it and create it, and then somebody else will take it.
Right.
And now they actually own it. Right. So if somebody wants to actually go about setting it up, right? Like what's the steps of legally copywriting something or trademarking, or if they don't know the difference, should they do it via a lawyer? Can they do it themselves online? What's your advice?
Okay. So, one, I have to give a disclaimer. So for anybody who's listening, what I say is for information only. I'm not your lawyer unless you hire me, right? So just have to say that. But, so if they want to, so the thing is, you should always hire a lawyer, because just with anything, like if there's somebody who's an expert in the field, you want to kind of rely on that person's expertise for nuances and things like that. But that being said, you can do it yourself. Like for copyrights, you could go on copyright.gov, and they make it really easy for you. So they kind of lay out, what are you trying to copyright? Is it, music? Is it a book or something? Is it? So they give you the options, and then you select, and they kind of walk you through the application process, and you could kind of click on stuff that will give you like explanations, like if you're confused as to what they're asking. So that's that with copyright. With trademark, it's a little bit more technical. So again, I do think you should get a lawyer, but their website has tons of videos on how to do it. It gets overwhelming, but if you feel like, I want to protect my stuff and I just don't have the money to invest in an attorney, they have videos that you could look at. And it's also sort of like you could be walked through the process. But the search is a little more tricky, because it's just so much to go through, and their website is not really set up to give you like comprehensive results. Yeah. Like you could type in Starbucks with two S's at the end, 2 S's at the end, and nothing will come up. You know what I mean? So, but if you put it, exactly how it's spelled, of course, tons of stuff will come up. But, so that's how you can see how it's not that, it's not that easy for someone who is just a layperson to do it. Sure. But it's possible. You know what I mean?
Okay. Speaking of trademarks, we actually behind the scenes were talking about a trademark case that people may be not familiar with, but it involves a high profile person, Jay-Z versus Iconix. Yeah. And for those who don't know who our Iconix brand is, they're actually the company he sold Rockaware to. You want to touch on that a little bit?
Yeah, sure. So Jay-Z sold his Rockaware brand, his clothing brand, to Iconix, right? And they're like a big clothing company. They own a bunch of different, clothing lines. And so they ended up suing Jay-Z because he has Roc Nation. And they're like, well, you sold us this. It had some value to it. And now you're still using it, essentially, like you're using Roc Nation. So, and that brand is already associated with you. So it's diminishing our value. And so they had a lawsuit, and they were going back and forth, and they actually ended up in arbitration.
So the arbitration process is like the really crazy part of the story, because during that process, he finds out that, hey, there's no diversity in the arbitrators. And he like files a suit for that, and he wins.
Yes.
And
okay, arbitration process is sort of like an outside of court process.
I was going to say, because people that might not know what arbitration is.
Yeah. So in most contracts, especially like when it comes to business, there's going to be an arbitration clause. So they don't want to have to go to court, like the normal avenue, go to court and have a judge decide. They rather go to like basically like a boardroom and have someone who's an arbitrator sit and listen to everybody who's like specializes in that area or whatever. So the parties get to choose who that arbitrator is going to be, right? They get a list, they get to vet and agree on who that person is going to be, or maybe a few people they'll choose. Yeah. And so what Jay-Z said is that, wait, there's nobody of color on this list. There was like, I think there were like 2 people. 2
out of 100.
Yeah, something like that. And so he was like, no, I'm not doing this. So he basically said, I'm not going to go forward with the arbitration, went to court. Yeah. And actually, before the judge made a decision, the company was like, you know what, we're going to make sure that we do right and go out and get more African American and other people of color to be able to make.
So
these
he's
decisions.
indirectly providing opportunities for people of color.
Absolutely, like he changed the game,
Yeah.
like he does.
I mean, exactly, on so many levels. Like every time we bring, it's like another way to change the game.
Jay to the rescue again. We've kept our streak of talking about Jay-Z
every single
episode. We've been consistent.
Mandatory.
Yeah. All right. Well, one other thing before we go to the next segment. Can you just briefly talk about licensing and what that entails?
So when you own these different types of intellectual property, patent, copyright, trademarks, the way that most people kind of really make money from them is that they license them to other people to use them. So as you build your brand kind of has clout, for instance, who was it? Jeff Bezos just bought the Washington Post.
Washington Post.
Yeah. So we know newspapers are dying, right? So you can get news everywhere now. So, but that name has a certain amount of status. So like if something's in the Washington Post, you believe it, right? So that's what people, once their brand creates value or has a value to it, you could license that to other people because like say if they put out a story on the Washington Post, say it was a license and they licensed the name to him. He puts out a story, people are going to believe it. So that's why people want to license established brands. And so you can do it in terms of allowing them just to use it for a certain purpose or in a certain area or to do, in connection with something specific. So you could do it broad or narrow and you could get royalties from it or you could just charge a fee for it. And that's going to be through like a contract.
Okay. All right.